Please start the recording and also call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Princess Montpelier versus J. Gill et al. Case number 24 AP 035. Appellant, Princess Montpelier, is self-represented and is appearing by phone. Representing the appellee, J. Gill et al., is attorney Steve J. Bonnet.
Okay, thank you, and good morning again, everybody.
Good
Ms.
morning.
Ms. Appellant, can you hear me okay?
Yes, I can. Thank
And
you.
we can hear you. You understand you have 5 minutes?
Mm-hmm. Yes.
Okay. Yes, and we'll give you an alert when you have about a minute left. So please go
Thank
ahead.
you. Okay. This case stems from June 5th, 2023, when I was denied a room at the Days Inn in Rutland, Vermont. And they falsely said that they were no longer participating with the voucher program with Economic Services Division. And they were wrong. And I recently received the notification from the office of Chris Winters, the current commissioner for Economic Services Division, which counteracts the basic premise that they were no longer participating. Furthermore, they were untruthful that there was not a room available to me that I had canceled, but I canceled one via the 800 number because Kevin Hatton, an agent for Economic Services Division, had advised me that on June 5th, I would have a room until July 1st, 2023. Further, Linda Walk had placed me on Do Not Rent list, and this was after I sent a letter to her admonishing her behavior when I was there from December 15th through the December 17th of 2022. And even though she says that I broke policies, etc., well, the picture of her smiling, I know about 11 a.m. on December 17th, it's contrary to what she said because she was smiling broadly, and this is the day I was checking out on December 17th of 2022. Furthermore, that night is when I spent one night at the transit center in a lot of pain, and as opposed to Mr. Bonet, I never stated in my complaint that a security officer escorted me out. I said that medical security. I never said I was escorted out, okay? I spent a miserable night, and not only in physical pain, but mental, emotional anguish that I didn't know if I would be shot that night or night down. Further, there was no bathroom available. I was urinating on myself. That is just horrendous. And if it wasn't because I was praying the Memorare to the Virgin Mary, I don't know what I would have done. Somehow I survived that night. Then I called Kevin Hatton, and he told me that there was a room available for me. I was there one night, the 6th, and then on the 7th, when Linda Walk came back to work, Kevin Hatton called me on June 7th and advised me that I had to leave the next morning because the staff was complaining. Okay? And that was Linda Walk, nobody else, in my opinion. In any event, Mr.
Now, 1 minute remaining.
You have 1 minute.
Okay.
Okay. Yep.
Okay. I'll save that for a rebuttal. Thank you very much.
All right. Thank you very much. We'll hear from counsel for the appellee. Please identify yourself and your client and then proceed.
Thank you. Good morning, Your Honors. Attorney Steve Bonnet representing all defendants, Jay Gill, Linda Wolk, Dazin, and Vitasar Gudapelli. Thank you. First, Ms. Montpelier appeared to be attempting to argue the merits of the case, and that's not what we're here for today. We're here on her appeal, where she raised certain issues presented to the court. The first one she raised is whether she failed to timely answer the defendant's motion to dismiss with prejudice. The facts and the time periods were clearly set out in Apley's brief. She did not timely answer the motion to dismiss that was filed by the defendant. In fact, the court had granted her an extension originally, and on December 27th of 2023, the court granted an extension to March 1st, which was in error, even based on the motion that Ms. Montpelier had filed. Immediately, counsel for the defendants filed a motion to reconsider. It was done that same day. That same date, the court granted the motion to reconsider, and gave Ms. Montpelier until January 23 of 2024 to answer defendant's motion to dismiss. In its order of January 25 of 2024, when it granted the defendant's motion to dismiss, the court clearly noted that Ms. Montpelier did file a reply to defendant's opposition to plaintiff's motion to amend her complaint. As such, she had the ability to respond to defendant's motion to dismiss. She just chose not to. So the reasoning by the court was there. It followed court rules. It followed court procedure. Everything was done properly. In fact, I don't believe to this date Ms. Montpelier has ever filed a response to the defendant's motion to dismiss. On or about January 31 of 2024, with other motions, she filed something called a motion to quash, motion to dismiss with prejudice, which did not follow any of the court-required rules for objection to a motion to dismiss. And certainly she never filed any motion to reconsider with the Superior Court. Another issue that Ms. Montpelier raised on appeal was whether Judge Burke correctly and fairly ruled on the motion to dismiss, which I've just addressed. That was her second issue raised on appeal. And then her third issue appears to question how the judges in the Superior Court handled this case, whether in fact they followed any proper procedure or instructions, which certainly is without basis. So for all of the reasons set forth above, the appellee requests that the lower court decision be upheld and the motion to dismiss with prejudice be upheld and the case go away. I'll reserve any time I have for rebuttal as well. Thank you.
Well, you don't have any opportunity for rebuttal under our rules, counsel. So
Okay, thank you.
if you do have some time left, if you want to use it, you need to use it now.
Thank you. I appreciate that. Unless the court has some questions, then I will take no more time. Thank you.
All right. I don't see any hands, so thank you very much. How much time does the appellant have, please?
Appellant has 55 seconds remaining.
Okay, Ms. Montpelier, please go ahead.
Okay. On January the 1st of 2024, I contracted COVID-19. I filed a motion with Judge Burke requesting to extend the time to the 31st of January to file my motion to quash. And as far as I'm concerned further, Judge Samuel Hall never removed or extracted the due date of March 1st. But the main emphasis I'm trying to make is that I file a motion with Judge Burke because of contracting COVID-19 on January the 1st. In fact, I had been sick for a week. And to the best of my knowledge, he never responded. And if he did, later on, I got knowledge of he had refused or declined 2 of my motions.
Appellant, no
But-
time remaining.
Thank you very much.